This is Professor Robert Monroe. This session is on financial investigations. I've posted quite a few readings on financial investigations. Some of them are quite long. I'd ask that you skim read them or focus on, read and focus on the key points in the documents. There's also some videos that are quite good. This is actually a fascinating area, and a consistent part of law, but also a practice, guidance, techniques, policy, and so forth. In regard to internal investigations for businesses and particularly financial institutions, internal investigations can be performed for any number of good reasons. Usually, the typical situation is that the internal investigation is caused by a government investigation of possible illegal activity. And the bank or financial institution might learn about the situation in a variety of ways. It could come to the attention of the institution from third parties such as customers, from the employees of the bank, from receiving a governmental subpoena, or having a government law enforcement people show up at the institution with a search warrant, or the filing of a civil lawsuit against the bank, or learning that government investigators are asking questions of employees. An internal investigation and a bank investigation may be appropriate in two different situations. The first is when the bank or a non-bank financial institution suspects wrongdoing prior to a government investigation. And obviously the second situation is where the government investigation started. The decision whether to start an internal investigation has to be made by the board of directors of the bank or financial institution. There are risks in conducting an internal investigation. One risk is that the report of internal legal counsel or external counsel written for the bank or non-bank financial institution will detail the results of the investigation, and it might have to be disclosed to the government and possibly to the third parties in civil litigation. Also, the internal investigation can turn the employees against the company, or make them so concerned about their liability they cooperate with the government and become witnesses against the bank. Very often, there's a need to conduct an internal investigation, and there are a number of reasons why a bank or non-bank financial institution will seek the internal investigation. Number one, they want to learn what has happened. They want to change it, make sure they want to respond to it and make sure it does not happen again. Three, the bank or non-bank financial institution wants to protect its reputation. And also, there are obviously federal, state compliance obligations that the bank or non-bank financial institution is concerned about. Also, if the financial institution decides upon an internal investigation, it may help the bank avoid criminal proceedings and also possibly reduce the amount of fines, penalties. There are different types of investigations. In all of them, there are commonalities. And in the case of a government investigation, a more serious investigation, the internal investigation by the bank or non-bank financial institution will allow the CEO, the board of directors, to learn what has happened. Then the counsel, the internal bank counsel, can meet with the prosecutor or government agent and determine whether what is happening, what is being investigated. At that point, the senior management of the bank has to be in control of the situation. The bank officials usually create a small team of key managers headed by the in-house counsel, in-house attorney for the bank, to manage the situation. Also, the internal and external auditors have to be contacted. In many institutions, internal legal counsel is acceptable. However, if there's a government investigation, the possibility of criminal penalties, usually it's highly recommended that the bank, the non-bank financial institution, obtain outside counsel. As I said, usually a team of experts are created, management with internal counsel. They try to find out what has happened and keep everyone calm. If there is a need for outside counsel, they go through those steps. If it does, if there is outside governmental investigation and there's a possibility of criminal prosecution or indictment, you probably want, let me restate that. There are two different situations. If it's a preliminary investigation or an account seizure, usually a bank lawyer might be acceptable. If it is a more serious criminal prosecution, then it is smart for the institution to obtain outstanding counsel with qualifications in the area of anti-money laundering and compliance criminal prosecutions. So it all depends upon the investigation and the type of the charge. If it's a relatively less serious charge, a civil violation, and there's little chance of a serious criminal prosecution, local bank counsel, either internal corporate counsel or local bank lawyer counsel will be acceptable. The more serious cases would require defense counsel trained in the area of anti-money laundering, fraud, corruption, compliance, and so forth. During the investigation, it's extremely important to maintain control of documents, computer files. Obviously, an employee who is engaged in criminal conduct will very often try to destroy evidence. This can involve destruction or alteration of documents, deletion of computer files, and even in some cases, intimidation of other employees. So in the investigation, the in-house counsel and or outside counsel should locate the most critical documents to be placed under the control of the attorney. And employees should be instructed that they are not to produce corporate documents for any third party, including the government. And any requests for such documents should be brought to the attention of counsel. As far as government investigations, these come to the attention of the bank or non-bank financial institution in several forms: summonses, receiving a summon, subpoena, or search warrant. In regard to search warrants, it's important to know that a search warrant compels very little. It gives the law enforcement agent only the right to enter the premises and look for and seize particular items of information. A search warrant does not compel testimony. So no one is required to give any statements. If this does happen, a search warrant is contact legal counsel, review the warrant, ask for a copy of the warrant, ask for a copy of the affidavit that supports the warrant, and remain present while the agents record an inventory of all items they have seized and intend to remove, and ask for a copy of the inventory. If there is an oral request for documents, information from law enforcement officers, those requests should not be honored. There has to be the bank employees, legal counsel, they have to require a written request or they have to be served with a subpoena, summons, or court order. There should be no oral requests for information from law enforcement officers should not be honored. It has to be in writing. As far as the criminal liability institution, is a very important area, because when a company or the bank, non-bank financial institution comes under criminal investigation, the bank or non-bank financial institution faces potential criminal liability, even though the criminal behavior was the result of specific actions of employees. Under the criminal law of most countries, corporations, banks, non-bank financial institutions can face the same, or even in some cases more severe penalties than individuals. And as you perhaps know, corporations, banks, non-bank financial institutions are liable for the unlawful acts of directors, officers, and employees. This is the first presentation on financial investigations. There's going to be one more presentation. If you have any questions, please contact me at www.rlm1320@hotmail.com. I hope you've enjoyed this. There's more to come, so stay tuned, and I'll be with you shortly.